that the Office of the Director of Public Prosecutions has written to the Ethics and Anti-Corruption Commission withdrawing consent to prosecute former Kakamega Governor Wycliffe Oparanya, who was nominated by President William Ruto as Cabinet Secretary for Cooperatives and MSME Development. EACC has rejected the DPP's proposal and maintains that the letter by the ODPP was written after Oparanya's nomination. The letter by the ODPP is dated 8th of July, but EACC acknowledges receipt on the 25th of July. EACC is taking issue with the grounds on which the DPP has based his decision not to move ahead with Oparanya's prosecution. Olive Burrows delves into the simmering row.
The Ethics and Anti-Corruption Commission has read mischief into the decision by the Director of Public Prosecutions, Renson Ingonga, to review an earlier decision to prosecute former Kakamega Governor and now Cabinet nominee Wycliffe Oparanya for conflict of interest and receipt of irregular benefits. The Ethics and Anti-Corruption Commission, writing to the DPP, the Commission is of the strong view that the evidence obtained and availed to your office is cogent enough and meets the necessary threshold of proof beyond any reasonable doubt. In view of the foregoing, the Commission reiterates its earlier recommendation to charge all the suspects as communicated via our letter dated the 4th of December 2023 and concurred with by yourself in a letter dated 18th December 2023. Today, Oparanya's lawyers accusing the EACC of, quote, manifest malice for failing to clear Oparanya ahead of his approval hearing scheduled for Sunday in the National Assembly. EACC having advised the National Assembly clerk, the Commission submitted a report to the DPP recommending prosecution of the nominee on various charges, including conspiracy to commit an offence of corruption, conflict of interest, abuse of office, and money laundering. But on the 8th of July, the DPP reviewed his decision to charge, supposedly on receiving a letter from Oparanya's advocates, making the case that the monies Oparanya received from those who had secured payment for tenders when he was governor were not in fact kickbacks, but a loan, one which he had in fact sued over for failure to pay. The DPP, writing to the Commission, most of the charges proposed were premised on monies paid by Director of Sabema International Limited and Sesela Resources Limited, one Joseph Obulunji Okutoi, to the firm of Marende and Nyaundi Company Advocates, Honorable Wycliffe Oparanya's advocate, to enable Mr. Oparanya purchase a house in LR 10034 located in Forest Green Edge Villas in Karen. It has since been established that the monies alleged to have been money laundered was a loan. The DPP, continuing to write, the Director of Public Prosecutions finds it will be an uphill task to secure a conviction in this matter and has reviewed the decision to charge all the suspects in the matter and directed that the file be closed for lack of sufficient evidence. The EACC has, however, stuck to its guns, holding firm that POCAMLA defines proceeds of crime as any economic advantage derived directly or indirectly as a result or in connection with an offence, irrespective of the identity of the offender. In this case, conflict of interest is an offence under Section 42 of the Anti-Corruption and Economic Crimes Act. It is instructive to note that the courts have held that it is not necessary for the prosecution to prove a predicate offence before charging for money laundering. While ultimately the decision to charge rests with the DPP, the EACC, in publicly calling out the office of the DPP, has effectively challenged this regime's commitment to rooting out corruption in government, even when it may not be politically expedient. Olive Burrows, Citizen TV.